today sponsored by the Central Valley Regional HR Hotline. My name is Anna Manzano. I'm the digital media and event strategist here at the California Employers Association. Before we get into today's official training, just a couple housekeeping details to go over with you. So as you see, your audio is muted for today's presentation, but there are going to be lots of opportunities to engage during the training. You're already doing so in the chat, so keep that engagement up for us today. If you have any questions though about the content, you can head over to the Q&A box at any time, and we will do our best to address those as we go. So while one trainer is delivering the content, one will be managing the Q&A, so you will be taken care of today. Handouts for this training were sent out in yesterday's reminder email, but what I'm going to do is in just a moment here, I'm going to drop that PDF into the chat box. So once you see it pop up, you can click on the icon or the file name and it'll download locally to your drive. If you have any issues accessing that PDF, please just ping me in the chat and I'm more than happy to get that to you one way or the other. You will have the content. Last but not least, excuse me, we do have a survey. So at the very end, you will see a slide with a QR code asking you for your feedback. So we hope that you will take the minute to either click with your phone the QR code, or at the end of today, you'll see a browser window pop up once you cancel out of Zoom. And all you have to do is click opt in. So you can choose your own adventure, but we do hope that you provide us with feedback. It is a 5-question survey, very quick, takes generally about 1 minute to complete. So you'll see that at the end today. And now I would love to introduce our trainers today. We have Juliana Gabriel, who is our VP of Human Resources, and Eli Nunez, one of our HR directors. So Juliana, it is all yours.
Thank you, Anna. Good morning, everyone, and Happy New Year. We're very excited to have you join us for our discussion of the new employment laws for 2025. Before we get started here, I just want to give a big thanks to the Central Valley counties that have sponsored this event today, and also remind you that the Central Valley counties have partnered with our organization, California Employers Association, to provide you a no-cost HR hotline. So how this works is if you take a look at the right column there, this is all of the counties that would be covered if you're an employer located in one of these counties. You can call in to your hotline number listed there, Monday through Friday, 8 to 5, with any of your HR questions that you might have, and you will always get a live HR advisor, such as Eli or myself or one of our colleagues, to help you out. So you might have follow-up questions on some of the new laws, or maybe you have a question on wage and hour issues, administering a leave of absence, employee relations, you name it. You can take advantage of that no-cost HR hotline. So please, if you haven't done so already, we would love to hear from you. Don't hesitate to call into that hotline. Now, who is California Employers Association, or CEA? We are an HR consulting company. We have members located throughout the state of California and beyond. And our goal is to provide our employers peace of mind with exceptional HR compliance solutions. So if you're interested in having more support beyond just the ability to call in through the hotline, if you were to join as a CEA member, you would get access to our extensive library of sample forms, toolkits, and resources, which we're constantly keeping up to date with all of California's changing requirements. All of our members also get access to our learning management system with employee trainings, including free harassment prevention training. So as a reminder, that's something that we need to stay on top of every 2 years for our supervisors and staff. And we can also help you out with projects. So whether that's an employee handbook or training or consultation time. So we have really comprehensive HR services and support. We have our contact information below there and our website. So feel free to reach out to us if you would like more information on that. I do also want to note that today this presentation is for educational purposes only and should not be relied upon as legal advice. So although we're going over some of the new employment rules and bills, we are not a law firm and we're not providing you legal advice in this training or when you call into the hotline. So if there is an issue of legal significance that comes up for you today, maybe we're going through the training and you realize you haven't been paying someone properly, or maybe they're misclassified, make sure that you consult an attorney about that and get some attorney-client privileged advice. But as Anna mentioned, we're more than happy to answer general questions about the content today. And so you're going to want to put that in the Q&A box While I'm presenting, Eli's going to be in the Q&A box answering all of your questions, and then we're going to do a little switch halfway through when Eli is going to present. All right, so let's talk about what is on our agenda today. Anna is right, we do have a lot to cover. So we are going to start with wage and hour updates. It's so important in California that we know how to pay people properly. And it's pretty complex in California as compared to other states, being sure to track all of the wage requirements, exempt employee salaries. So we're going to go over that. We're also going to discuss something known as the PAGA reform that happened last year, which is going to change how wage and hour lawsuits are litigated going forward. And it has some new important to-dos for employers. If you're not familiar with what that term is, that's okay. We're going to go over some context for that. And then we are going to also go over a new bill regarding independent contractor protections for 2025. For employee rights, we're going to go over some new rules regarding captive audience meetings, particularly relevant for discussions on union activity with your employees. Also, there's some new laws with protected classes and clarifications around that, and also prohibitions regarding what you can now put on a job advertisement or posting. So that one's really important. The second half, Eli is going to take over with leave and benefits. So there's been some expansion of crime victim rights. We'll talk about that, changes to paid family leave, as well as a deadline for smaller employers regarding the CalSavers retirement program. Also with safety, we're going to go over some reminders regarding those workplace violence prevention and heat illness prevention plan requirements that went into effect last year. All right, so starting with our wage and hour updates, let's go over what are the minimum wages and exempt salary amounts for 2025. So as of January 1st, for your non-exempt hourly employees, they received a 50-cent increase. So it is now $16.50 an hour that we need to be paying all of our non-exempt hourly workers. There was a prop that proposed on the ballot to further increase minimum wages that did not pass. California residents did not vote in favor of that. So we are looking at that $16.50. And then also really important to remember, anytime that minimum wage goes up, this is also going to affect the minimum exempt salary for our white collar professionals under the professional, executive, and administrative exemptions. It's always 2 times the state minimum wage times 2080 hours a year gives you that annual salary amount of $68,640. And you are not able to prorate that based on hours worked. So if you have someone that you've been considering exempt salary, but maybe they only work 20 hours a week for you, you cannot prorate that amount. That is the minimum that you would have to pay them per year to be in compliance, in addition to that person satisfying the duties test. So for exempt employees, we have a few hurdles that we have to overcome for them to be properly classified as exempt. If we're not properly classifying them, then we risk penalties for that, wage and hour penalties for not giving them meal and rest breaks, for them not earning overtime. So you want to get this issue right. You can classify anybody as a non-exempt hourly employee. That's the default in California. So that's always okay to classify someone that way. But to be exempt, we have to overcome those hurdles. So if you're concerned about being able to sustain that salary amount in your budget, we have a great fact sheet for you on transitioning someone from an exempt employee to a non-exempt employee, and just some tips around that. Sometimes employees feel as though this is a demotion, so it's important to communicate why you're making this change. And then also, if they've always been used to being exempt and they haven't been tracking their time and taking breaks, it may take some time for them to get used to that. So you can put that bit.ly link in your browser and access that fact sheet for some tips there. Now in California, it's not quite that simple. So in addition to our state minimum wage, we also have local minimum wage requirements, actually now over 40 of them, that may apply in certain cities and localities where you may have employees working, meaning it's not going to be that $16.50 an hour. It's going to be a higher minimum wage when they're working in those boundaries. Also really important to remember that the local minimum wage is based on where the employee is physically working, not necessarily where your office or your headquarters is located. So a lot of employers really missed this during COVID when they sent people to go, work from home, and they didn't check, well, is there a local minimum wage requirement in that city where they're home? is based. A lot of these are in and around the Bay Area, as well as Southern California. So even if you're in the Central Valley, if you're sending people to client sites that are in the Bay Area, you're going to want to check for those local minimum wage requirements, or you're sending people, down south for a conference or something. You want to make sure to stay on top of that. So again, we have a really great link for you here to access a fact sheet of all of the current local minimum wage requirements. A lot of the local minimum wages automatically increase as of January 1 each year. And then kind of the rest of them, the majority of the rest of them will increase July 1. So at the beginning of the year and then also mid-year, we're wanting to make sure we're watching out for those minimum wage increases that may happen. It's tied to the consumer price index. So when we're experiencing inflation, we tend to see a lot of these go up. And one more point on this, the local minimum wage does not impact that exempt salary amount that we talked about. So that is tied to the state's minimum wage. So you're still looking at that $68,640, regardless of the locality. All right, and now we also have these industry-specific wage requirements that started in California last year with this fast food minimum wage that went into effect back in April. So many of you may have already heard about this, that there is now for fast food workers that work at a chain with over 60 locations nationally, for example, McDonald's, Starbucks, right? They're at a $20 an hour minimum wage. And in this case, that fast food minimum wage does impact exempt employees in that industry. They have to be earning a minimum of $83,200 per year to pass the salary test. So really important to know that if you're in the fast food industry. Another component to this is that the Fast Food Council was created under our Department of Industrial Relations, and they have the authority to recommend working conditions in the fast food industry and set minimum wages each year. So they did not do that for January 1st this year for 2025, but it is something that we want to watch out for, that we may continue to see further increases or even particular safety rules, for example, that they may propose to be part of the fast food industry. We also have healthcare minimum wages now in California that went into effect as of October 16th of last year. And it really started with this bill known as SB 525 that created this goal for healthcare workers to eventually earn $25 an hour. And I think probably the motivation or the impetus behind that was with what we saw during COVID, with our healthcare workers working very hard and in those difficult conditions. I think that's probably had something to do with inspiring the legislature here. Now, there was a couple little snags with this law going into effect. It was supposed to go into effect prior to this. It was delayed multiple times. It did finally go into effect, and it does apply to most all healthcare facilities in California. So hospitals, skilled nursing facilities, clinics, most physician groups. And the minimum wage that those employees are subject to is dependent on how their specific facility is classified. So depending on the type of healthcare facility, right now, the minimum wages range anywhere from $18 an hour to $23 an hour. And we do have set increases expected for June 1st of this coming year. Now, to qualify as exempt as one of these healthcare professionals, it's a little more complicated here for the salary test. Those employees must be paid either 1.5 times their healthcare minimum wage or 2 times California's state minimum wage, whichever is greater. So what that means is the employer is going to have to do a calculation anytime the healthcare minimum wage increases for them or California's minimum wage increases. They're going to have to do the math there to see what is the exempt salary amount that we need to pay to stay in compliance. All right, so we've gotten through the wages. The next thing that we want to turn to is personal vehicle usage. And there's nothing too new here, but we like to remind employers about this rule anytime the IRS mileage rate increases, with what you should be reimbursing your employees for when they are driving their personal vehicle for business purposes. So just to give a little context here, California's Labor Code Section 2802 says that we as employers need to reimburse our employees for all reasonable and necessary business costs, that is a cost of doing business that falls on the employer. And that includes when they are driving their personal vehicle for business purposes beyond the normal commute. So we do not need to compensate them or reimburse them for their commute to work. But let's say they arrive at work and then we're sending them off to a client site. That travel from there, if they're in their personal vehicle, we need to make sure we're reimbursing for that. Or maybe we send them to go pick up lunch for the office. And so they are driving a little bit for that to go pick up lunch. And we need to make sure that we are reimbursing them for their mileage and taking into account not only the cost of gas, but also the cost of maintaining insurance, the cost of wear and tear on the vehicle. And the IRS has basically come up with this formula for us that presumes that you have sufficiently reimbursed the employee. And so for January 1, 2025, they said based on inflation and everything, you should be paying your employees 70 cents for every business mile that they're traveling for you. So you'd have that employee track their mileage, and then we would recommend that you pay them that 70 cents per mile. If you don't do that and you decide to use some other method, if that employee brings a claim against you, the burden is going to be on you to prove that you've sufficiently reimbursed them. So it's safer to use that IRS mileage rate. Now, you also want to remember for your hourly employees, you also need to pay them for their actual drive time beyond their normal commute. So that's also time on the clock that's compensable, in addition to paying them for that gas, wear and tear, et cetera, with the IRS mileage rate. So those are two separate things. This business reimbursement with the IRS mileage rate does apply to both non-exempt and exempt employees, but that compensable time, that time on the clock, would only apply to your non-exempt workers. All right, so let's move right along into the PAGA reform that I mentioned. So for those of you that are not familiar with PAGA, what this stands for is the Private Attorneys General Act. And this is a law that allows employees to bring claims against the employer on behalf of themselves, as well as other employees, for labor code violations. So they basically get to step in the shoes of our California Labor Commissioner and pursue those violations and enforce penalties against the employer for that. And under the labor code, oftentimes it's wage and hour violations that they are pursuing. So whether the wage statement was inaccurate, or maybe they're saying you're not providing employees sufficient meal and rest breaks. So it's not just a single employee, but typically it's an employee bringing it on behalf of a group of employees. And it's been really costly for employers over the years. They can get hit with multiple PAGA lawsuits, and that's on top. Those are penalties on top of whatever it is that they actually owe the employees for those violations. So there's been a lot of criticism of PAGA over the years by employer and business groups. And there was a proposal this year on the ballot to try to basically gut PAGA, pretty much get rid of it entirely. That did not happen. What ended up happening is the legislature reached a deal with business groups to make it a little more employer friendly. So it's still here, it's still around, but now there's certain components to PAGA that help an employer out if they are met with one of these types of claims. So as of July 1, 2024, AB 2288 and SB 92 were signed into law that make changes to how these types of wage and hour lawsuits are going to be litigated going forward. Now, you may have never been hit with a PAGA lawsuit, but there are now important components that whether you've been hit with this type of a lawsuit or not, that all California employers really should be paying attention to. We're not going to go over all of the reform because a lot of it is more relevant for attorneys who are going to be defending these types of claims. But here is what really all California employers should know now. There are new opportunities that if you were to get hit with one of these PAGA lawsuits in the future, and I can tell you that it started off with mostly large companies getting hit with these lawsuits, but we've seen in the recent years much smaller and mid-sized companies start to get hit. You can reduce your penalties in certain instances by up to 85%, which could be thousands, if not tens of thousands of dollars in damages or in penalties, if you show that you as the employer have been taking reasonable steps to comply with wage and hour laws, that you show we are an employer that is trying to operate in good faith, basically. And in the PAGA reform, the legislature has spelled out for us, luckily, what those reasonable steps are. So they say they want to see that employers are conducting periodic payroll audits and taking action in response to those results. So, for example, you should periodically have someone in your HR department or a third party, maybe your attorney that you bring on, right, that is taking a look at your payroll records, looking at those time, those punch in and punch out. Are we paying people overtime properly? Do we have a practice where there's people that are not punching in and out and they're working off the clock? Are we paying the regular rate of pay when we're paying them overtime, when we're required to do that? Do we have meal and rest breaks that are appearing to be insufficient or not taken on time, right? And then cleaning those things up and making sure you're getting the company in compliance. The second thing would be distributing lawful written policies. So making sure that you're keeping your employee handbook up to date, and particularly your wage and hour policies on meal and rest breaks, for example, that you're distributing those to employees, they're acknowledging and signing off that they understand what their rights are. Training supervisors on wage and hour compliance, so on our labor code rules or on your wage order rules. I imagine that most employers or many employers probably up until now haven't really had formal wage and hour training for supervisors. I think it probably a lot of the time has happened informally on the job. And this doesn't go so far as to make it a mandate, but it's a really good idea to start having some sort of formalized training for your supervisors on wage and hour. And then taking corrective action for supervisors who are not following your policies. So, for example, if you have a supervisor that's interrupting your employees during their meal break, and now that's not a compliant meal break, making sure we're following up, we're coaching and disciplining them as needed. Another component to this that I just want to quickly mention, if you do get hit with what's known as a PAGA notice, putting you on notice that someone may pursue those PAGA penalties against you, there are, under the new law now, new opportunities to cure certain violations early on before they would even end up to court. But those cure provisions are very specific. It depends on the type of violation at issue, whether you're able to cure it or how to cure it. So just make sure if you do ever receive one of these PAGA notices, promptly consult legal counsel so that you can learn about all of your best options in that scenario. CEA does offer a wage and hour audit package, which comes with an audit checklist to help you assist you through your own payroll audit, as well as a 90-minute training for your HR staff on wage and hour fundamentals, as well as some of the more nuanced issues. And that also as part of that package includes a recorded wage and hour training for your supervisors that it's about 30 minutes long. So that can be a really great resource if you want to start to put these things together. And that is available on our store at employers.org. All right, and the last wage and hour bill or new law that I want to go over with you is this SB 988 relating to independent contractor protections. So remember, in California, we have a very rigorous test under most circumstances to classify somebody as an independent contractor in the first place. It's known as the ABC test. So it's already very difficult to properly classify someone as an independent contractor. SB 988 is not changing that test at all, but it's saying if you do have an independent contractor that you're bringing on in certain cases, assuming they're properly classified, there's still an additional step that you need to take, that in certain cases, you have to put the contract in writing. You can't just verbally agree or have a handshake agreement. There has to be certain information in that written contract. So this is when it would apply. So if you ever bring on independent contractors or 1099 workers, make sure you're paying attention. If it's an individual person, or if they have a business license or an organization, but they are the only employee, and you are going to be paying them $250 or more for their services, in many instances, you now have to have a written contract for that. That would include the name and mailing address of each party to the agreement, the list of services that they're providing you, the value of those services, the rate and method of payment, and then the date that they are due to receive payment. There's also some additional protections in this law that once the work has started, the hirer cannot start to change the terms. So they can't say, well, we're going to only pay you on time if you accept less compensation from us, or you need to provide more services for us before we're going to pay you, or give us more rights. If the hirer tries to do that, the independent contractor could go after them with a legal claim, including for retaliation. So they do have the right to sue under this new law, or it could be enforced by a state prosecutorial agency. So there is some teeth to this new bill. Now, if you are in this situation, I would always recommend consulting with an attorney to put that written contract together to make sure that it's legally compliant. And also, we recommend anytime you're classifying somebody as an independent contractor in California, it's a really good idea to get legal review of that. Because if you've misclassified them and they really should not be an independent contractor, you're risking all of those wage and hour penalties that we discussed: missed meal and rest breaks, missed overtime, etc. There's a lot of penalties that can flow with misclassification issues. So here are the current services covered under SB 988 if you're bringing on an independent contractor to do one of these things. So I'm not going to read the slide to you, but just know things like marketing, HR administration, photography, right? A lot of these other services would be covered if you are bringing on an individual for that. All right, so I'm going to wrap up on our wage and hour to-dos, and Eli can jump in here if he has anything to add or any questions, but ensure that you are paying those appropriate minimum wage rates as well as salaries. And then we recommend start implementing those reasonable steps in light of the PAGA reform. So make sure that you have someone on it in your HR department that's going to go over making sure you have a payroll audit practice, supervisor wage and hour training, and then review those independent contractor arrangements with your legal counsel. All right, so moving right along here to employee rights and protections, we want to start with this new EEOC harassment guidance that was published last year. It was a big deal because it was after nearly 25 years that the EEOC updated its harassment guidance. And they really now just have more complex examples and clarification than we ever really had before. So we have some of the key highlights here. I'm not going to go through all of this in the interest of time, but we would recommend, if you're an HR professional, taking a look at some of those new examples. One of the big ones is this concept of intersectional harassment, where the EEOC has clarified that harassment can be based on more than one protected characteristic of an employee. So it's kind of the unique combination of those things. An example that the EEOC provides is targeting someone or harassing someone or assuming, for example, that an older woman is menopausal or hormonal. It's based on stereotypes that are about both age and gender in that case, stereotypes about older women. So it's not just one protected class at a time that we could be looking at, but someone could bring a claim that it's really because of the combination of those unique factors that are brought together. Now, California followed suit here to align with the EEOC guidance on this. So a new bill this year was SB 1137 that amends FEHA's definition to cover this concept of intersectionality. So in terms of practical to-dos here, I would just recommend that you review and update your employee handbook policies, your anti-harassment policies, to include now this concept of intersectionality. And it can be something as simple as noting that employees are protected from discrimination or harassment based on any of the protected classes or any combination of two or more protected classes. So we have that language kind of bolded for you there that you could work off of, but just make sure that you're updating that in alignment with the new clarification and guidance. All right, this next one is an important one, SB 1100, and it has to do with what's known as driver's license discrimination. So now in California, employers cannot require a driver's license on a job advertisement, posting, application, or related materials. So here the legislature has a concern that if you have a blanket requirement to have a driver's license on a job ad, that you're going to be discriminating against certain groups of people potentially that would be able to perform the job. Or maybe, they have an arrangement to get to work. Someone can drop them off. They can ride share with another employee that they don't necessarily need to drive. Now, when could you still require a driver's license? If the employer reasonably expects driving to be a function of the position and believes that alternative transportation would not be comparable in travel time or cost. So what that means is if you're hiring someone that you anticipate they'll maybe need to do some driving for you, you're going to want to look at, well, could we come up with an alternate arrangement? Let's say you have someone in your office that they occasionally need to go and make deposits at the bank, but the bank is just 5 minutes away. Maybe they can walk, maybe they can bike, and it's not going to be that much additional time or cost to do that. Using CEA as an example, we have trainers that we send out to different employer sites all throughout the state of California that they need to be able to drive there. And it probably would not be comparable in time or cost to have them taxi or Uber. It'd probably be much more expensive to do that, right? So that's an example where we may have a strong argument that we can require that driver's license when we're hiring trainers to do that. So what I would recommend is take a look at your job postings and your application materials, and I would probably remove any sort of blanket driver's license requirement and instead add it back in on a case-by-case basis. Make sure that someone's always kind of analyzing and reviewing that in your HR department so that you don't end up with a driver's license discrimination claim against you. Another one is this captive audience meeting bill that came out this year, known as SB 399. So now in California, employees have a right to decline to attend meetings or listen to communications regarding an employer's opinion about religious or political matters. So basically, they have a right not to be a captive audience. They could voluntarily leave. They don't have to listen to that. These terms are defined pretty broadly. That's probably the biggest point that I want to make here. So religious would be an employer or agent of the employer, like a manager's opinion on a religious affiliation or practice, if they were commenting one way or the other on that. Political matters can include anything from new legislation to elections, elected officials, as well as unionization. So the employer's opinion on whether employees should unionize or not, or employer's opinion on a labor organization. Have to be really careful there. You can communicate just factual information about a new rule, right? The minimum wage went up to $16.50 an hour. You can communicate that, but you're not going to want to comment on new legislation, your opinion on it one way or the other, or you could run afoul of this rule. Now, I have seen legal challenges being made to this law, arguing that it is not constitutional, that it's preempted by federal law. So we'll have to see what happens here. But as of right now, I would recommend that you at least train your supervisors and managers on this so they're aware of how broad this can be, and that they know if an employee chooses to leave, if someone starts to get into their opinion on one of these things, manager or supervisor, that they have a right not to face any sort of adverse action. So that time wouldn't count against their attendance. They can't be disciplined or retaliated against. And they would also still have to be paid for that time under this new California law. Now we have something similar on a federal level. So, and particularly around communications regarding unions. So historically, on a federal level, captive audience meetings were allowed, where you could call employees in for a meeting to discuss the employer's opinion on a union or labor organization. However, just recently in November 2024, the National Labor Relations Board ruled that mandatory captive audience meetings are unlawful. I think we may see that change within the next year with a new administration in office. So this area in particular, I think we could see kind of the pendulum swinging back and forth. Again, the California version's being legally challenged, so stay tuned, but I would recommend some training for your supervisors and managers on that. Make sure to go over that with them. All right, and finally, labor law poster updates. This is the season when you want to be paying attention to making sure all of your notices in your workplace are current and up to date. So as a reminder, there are around 30 state and federal notices that employers need to have posted in their workplace in a conspicuous location where employees can read the information and access. So a lot of employers will put their posters in common room or common areas and break rooms. And a lot of employers like to get an all-in-one poster that includes all of the notices on one nice sheet. Here are some of the ones that were updated this year. It's pretty much every year around this time that these posters are updated. Sometimes there's mid-year. So for this year, the California whistleblower poster was updated. The labor commissioner just added some additional clarifying language regarding whistleblower rights. So, for example, if an employee goes and makes a complaint to Cal OSHA, that they're protected for that, right? Or they are, file a lawsuit. The minimum wage posting also changed, of course, because the minimum wage went up. And remember, if you are in fast food or healthcare, you have supplemental minimum wage posters that you would also want to include in your workplace. The workers' comp poster for California also changed just to clarify that the employee has a right to consult an attorney if they have a workers' comp issue. And it also notifies the employee that in most cases, if they get a workers' comp recovery, that their attorney's fees will be paid from that recovery. And then the Civil Rights Department also is updating a couple posters, the discrimination harassment, in alignment with some of those new rules that we went over with intersectionality, and also they're addressing the expanded crime victims that Eli's going to go over in just a minute with you. And then they also made some changes to their family care and medical leave and PDL. If you still need an updated all-in-one labor law poster, that is available on our store at employers.org. So that is something that you can order to make sure that you're in compliance with those posting requirements. All right, so employee rights and to-dos. Make sure you're staying up on harassment prevention training. As I mentioned at the beginning here, that's due every 2 years. We recommend those tweaks to your handbook policies. Really important one is review the job postings to make sure you don't have a blanket driver's license requirement. Train your supervisors on captive audience meeting rules, and then make sure you have an updated labor law poster for 2025. All right, and we are more than halfway through here, but we are kind of need to jam through this material. I know I went a little over for you, Eli, so I am going to stop sharing and let you take over.
No worries. I just want to remind our listeners too. I saw the comment come up about posters not being shipped out yet. Just if you have any kind of inspection or something, you can show proof that you have ordered the poster and that it's on its way, and that should be enough to satisfy those state agencies too. So just make sure hold on to your receipt showing that you did order it. It's on the way. As soon as we get those final updates from the state agencies, those will be shipped out to you as well.
Thanks, Eli.
All right, well, let's jump into our second half here. We'll talk about leave laws and benefits. And as Juliana mentioned, there is an update to the Crime Victims Leave. That's AB 2499 that came through effective January 1st of this year. And just a reminder for the Crime Victims Leave, this is basically a requirement for all employers to provide time off for their employees if they have to be on jury duty, witness duty, or if they were seeking a restraining order or any other kind of legal relief for anyone if they were a victim of a crime or for their child. It also allowed employees to use their PTO to cover that time. So whether it was sick time or vacation or whatever they had available. And, really it meant that employers needed to almost have this interactive process, right, to provide reasonable accommodation to make sure that there was safety provided to employees if they were the victims of domestic violence, sexual assault, or stalking. And of course, employers also had a duty to maintain confidentiality during for these matters. Now, think about AB 2499. It didn't change any of those existing protections, but it did expand on the protections quite a bit. So the big thing, the big change was it changed the definition of what the victim is. Under the old law, basically it applied to the employee themselves or their child. Well, now it kind of expanded that coverage to family members of the victim or family members as well if they're the victims of a crime. And we'll talk about what exactly that family members mean or which ones apply. Um, you know, Employees can still use their paid sick leave or vacation for any of the purposes that apply to this law. And the new thing as well that came across is that now employers have to provide notice of these rights to their employees. And it's not just a thing where you're supposed to, put the poster up and you're good to go, right? Under this new law, you have to give notice to the employees once they're hired. So once you give them their new hire packet, make sure that you have notice that you give them the notice of their rights under the Crime Victims Leave under AB 2499. You have to give them this notice annually thereafter. And then if anyone lets you know that they need to take leave under these protections, you have to give them a copy of those rights as well, or a copy of that poster. Now, in true fashion, as we've gotten used to, sometimes the cart gets put ahead of the horse. We've yet to see the new notices put out by the Civil Rights Department, and they've informed us that there should be a new notice out by July 1st, 2025. So I guess the good news is, we don't have to provide the notice as of yet because the notice doesn't exist. So once the CRD puts that notice together, gets it ready to go, then we have to start providing that to new hires, to employees, to anybody that requests a leave or protection under these rights. As I mentioned, the definition of victim was changed by AB 2499. Basically, the victim now can include either the employee themselves, their child, or a qualifying family member. And family members for this law, if you take a look at it, it's very similar to what we see under CFRA protections, the California Family Rights Act protection in California. It includes, family members like child, parent, grandparent, grandchild, sibling, spouse, domestic partners, or even a designated person. And again, that's similar to the CFRA protections in the state of California. And just like CFRA too, you could limit that designated person to one person per 12-month period. So, you can't have an employee come in and say that, their designated person this week that they have to take time off for is their best friend, and then next week it's their neighbor, and the week after that it's their cousin's best friend's aunt or something like that, right? It's one person per 12-month period, so it does provide a little bit of coverage for us as employers. Now, the qualifying acts of violence, again, very similar to what was already in the law previously, any domestic violence, sexual assault, stalking, that sort of thing, or any act that, basically includes things like bodily injury or death, exhibiting, drawing, brandishing, using a firearm, basically any kind of threatening behavior like that, or threatening to use force. And if this sounds familiar, for those of you that have done workplace violence prevention plans, they kind of intermingle a little bit there. So, just keep that in mind as well. So, again, if you're a larger employer too, that you have 25 or more employees, there is also some other changes that can affect you as well. Again, the prior law said basically, employees were eligible for time off from work if they were victims of a crime, they were looking for any kind of medical or mental care, um, or any kind of victim services, right? And that could be things like, finding ways to maybe leave an abusive situation, or leave a harmful situation, that sort of thing, in addition to court leave, in addition to court hearings or seeking a restraining order, anything like that. Well, um, AB 2499 expanded on these rights for employees. Now, the employees have the right to take time away, not only for them, but again, for a relative, if they're looking for, any kind of court order or relief from a legal system, their for their protection, any kind of legal proceedings, again, any kind of medical or mental health services, as well as safety planning. And this could be something, again, like relocating, if they have to move, if they have to find a new place to live, or if they have to, maybe enroll their children or their relatives' children in a new school, or that sort of thing. Those can all be, reasons for taking protected time away from work. Keep in mind too that the new law does provide for the ability to run the leave concurrently with any CFRA or FMLA leave if applicable. So that means if an employee comes to you and says they need time away from work because they need, physical or mental care for themselves due to being the victims of a crime, or one of their relatives does, one of their family members does, then you can get that CFRA or FMLA certification and run those 12 weeks of leave at the same time as that time away. Now, again, if you do that, make sure that you are providing all the proper documentation and letting them know that you are designating that leave, not just as crime victims leave, but also as CFRA or FMLA leave if it applies. Um, Now, keep in mind too that if the victim of the crime is not your employee, but one of their family members, then you can limit the time away if they are only using it for relocation or for school re-enrollment or anything. If that is the case and they're using it for that specific reason, you could limit that time to a total of 10 days, um, or 5 days when it's used for relocation or re-enrollment in school. So again, that's why it's important, to have those conversations with your employees. If it lets you know that they need to take that protected leave, really dig in a little bit, get to know the reason behind it, get to know what you can do to help, and what protections and what restrictions apply as well. Another change we saw this year for employee leaves and benefits was AB 2123, and this one applies to paid family leave benefits, or PFL. We usually see this used when employees take time away to either care for a family member, for baby bonding, that sort of thing. And the big change for this was that beginning this year, employers cannot require their employees to use vacation before their PFL, or their paid family leave benefits, kick in from the state. So, as you know, there's a waiting period before these benefits start. And before January 1st of this year, employers were able to require employees to use up to 2 weeks. In other words, that you could tell your employees that yes, you could take this leave for your CFRA, and if you're applying for benefits, you have to use 2 weeks of vacation or PTO during that waiting period. And that was kind of a way for maybe to lower those vacation balances or that sort of thing. Well, under this new rule, we can no longer require employees to use their PTO. They can still choose to do it themselves, so we can give them the option, but we cannot force them. We cannot tell them, hey, if you're taking, paid family leave or disability, wherever it is, you have to take 2 weeks of vacation first before your benefits start. So again, it is up to them if they want to use any of that PTO, how much, when they use it, et cetera, et cetera. So, thing to do about this too is, if you have any kind of policy, or if your handbook said that employees had to use 2 weeks or whatever time of PTO, make sure that you update their handbooks and remove any of that language. There was also, more updates coming to CalSavers. If you're not familiar with CalSavers, that's basically a California state program aimed for employees where their employer does not have any kind of retirement plan. So that there's no 401k or pension plan or anything. This is a state-sponsored program. Our responsibility as employers, if we participate in this, we don't have to pay anything. There's no basically there's no administrative costs or anything like that. We just have to maintain a roster and administer the deduction. So if an employee chooses to participate, we're deducting the money from their check and sending it into the state, into the CalSavers fund. New change for this year basically takes effect on December 31st. That is the deadline for basically all employers in California. So if you have one or more employee, then you have to register for CalSavers by December 31st of this year if you do not provide any other kind of retirement program. So if you have a 401k program or anything, you can just disregard pretty much everything I've said in the past few minutes. But if you are a CalSavers eligible employer and you do not have any kind of retirement program or anything, then make sure that you are registered by December 31st of this year. And again, our duties as employers, if we're participating in CalSavers, we're basically maintaining a roster, sending that information to CalSavers, and if your employees choose to participate, we're taking those deductions. CalSaver is the one that sends the employees any kind of communication on their benefits, on their investments, et cetera, et cetera. So all we're doing is administering the roster and any kind of deduction. So some to-dos for you as far as what we've mentioned here in the last couple of minutes. Make sure you update your crime victim and other affected policies. Again, there was a change to the definition of victim and family members and that sort of thing. So make sure that your crime victims leave policy reflects these changes. Keep an eye out for those new notices. Again, that Civil Rights Department should be putting that new crime victims leave notice out. They've said it'd be by July. Could probably happen sooner than that. So again, stay tuned to our blog. We'll let you know when that new notice comes out, or keep an eye on the CRD website. And once it comes out, make sure you distribute that to your employees. Update your leave practices, regarding paid family leave and vacation. In other words, if your policy said that you have to take, vacation before paid family leave, make sure you go back and rework that language to make it optional for employees to take any kind of PTO when it's related to paid family leave. And again, if you need to register for CalSavers, you have until December 31st or December of this year. I know it seems like a long time away, but that's what I thought about December 31st of last year and January 1st. So the year flies by. Better to get on it and make sure that you familiarize yourself with the process and with, the requirements. Now, some health and safety updates that we've seen throughout this year. Of course, the big one was the Workplace Violence Prevention Plan. Basically, this one came about earlier in the year, and it was a requirement for employers to put together, to establish, implement a written workplace violence prevention plan and to update it every year. So there's not just something that we put together once, and put up on the shelf and forget about it. It's a living document. We have to update it. We're required to update it every year, and we're required to train our staff on it every year. So a question we get, what are ongoing requirements for that? I mean, we know what the workplace violence prevention plan is, but what are my requirements as an employer? Well, some things to keep in mind is, you have to review this at least once a year, right? And reviewing means that you're getting employee feedback on the plan or on any other hazards that have been identified. So hopefully this is going to happening on an ongoing basis. If there's any changes or new things identified, your employees are coming to you and letting you know. Um, we're going to train our employees yearly on this as well. And then there's also a requirement for under the WVPP program for hazard inspections and a recommendation for safety meetings. So again, make sure you have those periodic hazard inspections, whether they're weekly, monthly, quarterly, whatever it is, make sure you're sticking to them. And if you did decide to put together safety meetings, make sure that you're having those and documenting those on a regular basis, because you can be sure if you get a visit from Cal OSHA or anybody like that, they're going to ask to see your workplace violence prevention plan and related documentation. So better to be up to date on that than to try to scramble, to find all that information. There was also indoor heat illness that came into effect this year, and this is something that they've been working on for a couple of years now. Finally came to light this year, July 23rd, 2024 to be exact, is when it went into effect. And this was basically aimed at, you know, basically hazardous indoor areas like manufacturing, restaurant kitchens, that sort of thing, where temperatures can really exceed, you know, the normal temperatures or what is considered safe, right? Basically 82 degrees is what they use as a threshold, and again, it's aimed at places without full air conditioning. But again, I mentioned manufacturing, I mentioned restaurants, kitchens, warehouses. It's not limited to that. So just really take a look at your workplace to see if there's anything that apply. Whether you have, specific workshops or sheds related to your area that aren't air conditioned, these could be areas where this standard applies to. And this is, very similar, or if you're familiar with the outdoor heat illness standard, this is relatively, this won't be a big change for you. It's somewhat similar to that, right? I mean, there's a requirement for written plan, for training, that sort of thing. This is very similar to that as well. And for CA members, we did create a heat illness fact sheet and some resources to help out with that. So some essential requirements under this heat illness plan is you have to provide your employees with potable drinking water, cool potable drinking water, areas to cool down. It could be like an air-conditioned office or break room or that sort of thing, right? Make sure that we are providing that for them. Have emergency response procedures. This should all be part of your written plan, as well as acclimatization, which means that, when you have someone that transfers to that location, when something changes or when you have a new hire, make sure that you're providing them with the opportunity to adjust to that new workplace setting or that new work environment. Again, there has to be a written heat illness prevention plan, provide training for employees and supervisors, and be aware of any high heat requirements. So when temperatures exceed 87 degrees or go beyond 82 degrees, but the employee has to wear protective clothing, such as, maybe heavy gear for welding or manufacturing, anything like that, or they're near any kind of radiant heat source, make sure that you are aware of those additional requirements that kick in at that point. And finally, for safety, hate bringing up COVID. It's been a couple years, but just a reminder that the COVID-19 prevention non-emergency standard is still in effect until February 3rd of this year. And there's still, certain record keeping requirements that'll carry over into next year. So again, I haven't seen a big resurgence of this, but the standard is still out there. And then once February 3rd rolls around, we'll see what Cal OSHA decides to do with it. There's been talk that it could be combined with the aerosol transmittable disease standard or anything like that. So just keep in mind that it's still in effect till February 3rd, and then we'll see what Cal OSHA decides to do with this. What they're going to combine it with, or what's going to happen to it. Bookmark for you there to keep in mind. That's going to help you with additional resources. We have a bit.ly link there at the bottom. Take a look at that to make sure you stay up to date with it. So things to keep in mind for safety in California as of 2025 now. Make sure you are complying with and staying up to date with the training requirements for your workplace violence prevention plan. If it applies to you, make sure you develop that heat illness prevention plan, whether it's indoor or out there. And of course, keep an eye on those COVID-19 requirements. Again, they're still in effect till February of this year, and then we'll see what Cal OSHA decides to do with this. And with all the, the COVID-19, there's also a requirement for COVID prevention plan as well. That's still in effect. So with all these plans, keep in mind, these are living documents. Make sure you're updating them. Make sure you have the right people that are responsible for certain areas of them listed. Nobody that's no longer with the organization is listed on there or anything like that. Make sure you're keeping these updated so that they are applicable to your needs. So, what's next for California employers? Want to make sure you stay up to date on your trainings, whether it's mandatory harassment prevention training, your workplace violence prevention plan training, or supervisor wage and hour training. Make sure your supervisors are up to date on what they can and cannot do so they help keep you out of trouble. Make sure your employee handbook is updated. Again, a lot of these laws that changed were things that were part of the employee handbook. So make sure that you take a look at it so that it complies with state law. Make sure you're compliant with new wage and hour requirements and pay attention to those local ordinances, especially if you send employees to work in other areas or if you're an out-of-state employer that has employees come to work in California. Make sure you're paying them correctly and offering the correct protections. Labor law poster. It's that time of year. Time to replace that old labor law poster in the lunchroom or break room or whatever it is. So make sure it's ordered. Make sure that you have it ready to put up there and you filled out all the right areas on it. And again, we always say, subscribe to our blog for any kind of updates that happen throughout the year. With that, I would like to once again thank the Central Valley counties that participate in the hotline for putting on this webinar, and remind you that we have those 800 numbers if you have any questions about anything we talked about today, or anything else really, or if you just want to talk about an HR issue, give us a call. We'd love to hear from you. If you need anything beyond what the hotline provides, we do offer different levels of membership for you with different benefits, of course. This is provided in the presentations. You can take a look, or you can give us a call if you want to discuss some of the benefits of membership. And if you find yourself in a position where you need a little extra help, maybe your HR manager or director is on vacation or taking leave of absence or something, you need someone to sit in that chair and help you out, we can help with that. Give us a call and we can talk about what we can do to help ease the HR burden for you. Now with that, I know Anna mentioned there would be a survey, and I hate making a liar out of her, so here is the page for that. Just go ahead and scan that QR code, and I believe it is also sent to you, or it goes to you right when the presentation closes, so please let us know what you thought of the presentation, what you'd like to hear in the future. If there's any topics that you'd like us to touch on or anything, we'd love to hear from you. And we also provide that feedback to the counties that we are teamed up with. And finally, if you're with us for continuing education, I do have some codes for you. For HRCI, it is 689145. And for SHRM, I have 25-E65, V as in Victor, K as in kangaroo, I guess. So with that, I think that wraps me up. I will go back to the slide for you to provide some feedback for us and turn it over to Anna or Juliana, see if we have any lingering questions or last words or anything.
Questions have all been closed out, so I'll give it to you, Anna.
Excellent.
Yeah, I know we're a couple minutes over, so thank you all for sticking with us. But I do want to direct your attention to the chat if you haven't been following along all the last hour. I did put the link to the next training coming up on February 27th. Again, this is sponsored by the Central Valley Regional HR Hotline, so we really do encourage you to take advantage of that employer resource available to you. But again, February 27th, hire right the first time. That's an amazing training that you are for sure not going to want to miss. Um, I know we always get this question about recording. So because this is sponsored by Central Valley, I will be sending them the recording file. Once that is available on their website, they then reach out to all of you, letting you know that that resource is available for playback. So stay tuned, stay on their list, and you will get a notification when that's ready. Thank you all for joining us live today, for bringing such awesome questions and for being so engaged. Thank you, Eli, and for Juliana for sharing your expertise and your time with us. And for sure, take advantage of those HR hotlines. Maybe you'll have the pleasure of working with Eli or Gigi or anyone on our team directly. So with that, Stephanie, yes, I do. Let me drop that in the chat as I sign off here. It is in your email if you did get that reminder email from me, but I'm going to look for it here for you. And there it is. That is in the chat for you. You just click it and it'll download locally to your drive, and we'll give her a second for that. But I, again, want to thank you all for joining us live, and we'll see you all in February. Cheers.